Thank you. So moving on briskly from one area of, in a sense, a failed tenure reform, a problem where we have a large population of people who have insecure, unregistered, unrecorded property rights and are liable to being forcibly removed. So we're going to have two other examples of the same kind of conundrum, and I'm going to present on issues around farm tenure, farm workers, and labour tenants, so people who are living on commercial farmland. And then we're going to hand over to Lauren, who's going to talk about questions around urban land tenure. So I'm going to keep this very short because Ben has eaten up a lot of my time. But I think that what he sketched out in the session before tea provided the backdrop to this, which is that we have a structural change that has been underway within the commercial farming sector, which has been an anti-land reform. It has been an anti-agrarian reform. And we've seen a concentration process, which has seen the reduction of the number of commercial farming units from an estimated 60,000 to around 35,000. Of course, these are just farmers who are registered for VAT, so there probably are quite a few more. But nevertheless, we've seen a very sharp reduction in the number of commercial farming units. And as this concentration has happened, and as the state has removed subsidies and forms of support that were built up over many decades under apartheid, so the provision of employment on farms has been declining. We'd have quite bad information about who lives and works on farms. We know that by the end of the 1990s, around 3 million people were living on farms. It's a significant proportion of our population. It's quite a large proportion of formally employed people within South Africa. Around 11% of formally employed people within South Africa are working on farms. And one way of thinking about this is that we need to distinguish between people who are employed on farms as farm workers versus people who are living on farms. It's a different category of people, farm workers and farm dwellers. Now, many people who are living on farms might be relatives of people who have an employment contract, but many do not. In fact, a lot of people living on commercial farms live there for historical reasons. So we need to address the fact that there are these distinct categories of people. Now, what has been the legal and policy framework for addressing the fact that we have a very large proportion of people within South Africa who have insecure tenure rights and are liable to eviction? Bear in mind that when we talk about the impact of the 1913 Natives Land Act, the major dispossession that resulted from that 1913 Act was forcible evictions off farms. It was largely the sharecroppers in the Orange Free State. The forcible removal of black people off the farms has been the big story of dispossession in the 20th century. And what we find, if we look at what's happened since 1994, is actually that there has been an acceleration of forced removal of black people off farms. There have been two laws that were established post-1994. One is the Extension of Security of Tenure Act of 1997, which provides certain kinds of safeguards for people who live on farms, regardless of whether or not they're employed. And then there is also the Land Reform Labour Tenants Act of 1996. So there are these two laws, ESTA and the LTA. And the difference is quite significant. Both of them provide certain kinds of procedural safeguards. Firstly, of course, nobody must be evicted without a court order. But the Land Reform Labour Tenants Act is a little bit like the restitution process in that it provided an opportunity for people who are former labour tenants, and this is mostly in Mpumalanga and KZN, people who historically provided free labour in return for retaining access to land. And this was a system through which black people retained access to land through much of the 20th century. It provided them with the opportunity to claim the land that they already occupy and use. The argument being that they've already actually paid for this through free labour. So the typical system of labour tenancy was 6 months of unpaid labour per extended family. That would have to be provided. Now, we know that there are about 21,000 claims. there's a huge issue, and of course there are a number of important court cases that have evolved from this. But more generally, I think that we can say that in the area of securing the rights of people living on farms, there's been massive failure. Over the first 10 years of democracy in South Africa, about 2.3 million people were displaced off of farms. And of those, around 940,000 were forcibly removed. In other words, they were forced to move off that land. And that's actually more than in the last decade of apartheid. And this is according to a major survey that was conducted by Nkuzi Development Association together with social surveys. It was one that looked at sentinel sites across the country and then extrapolated to arrive at some national estimates. But the point is that we need to understand that dispossession is not a historical artifact. It's been continuing in the post-apartheid period. Also, importantly, what we found is that less than 1% of those forced removals off farms involved a legal process. In other words, they weren't going through the court system. Now, of course, there are a lot of debates about both why this is happening and what to do about it. My view is that it's primarily structural changes within the agricultural sector. So often what we're seeing is new farmers taking over, downsizing the farm worker complement, and then evicting people. So we're primarily seeing this as an outcome of a structural change within agriculture. But also, we must see that there's been a massive failure of the state. We see, for instance, Section 4 of ESTA says that people could be able to acquire ownership rights of the land that they're already occupying. So Section 4 of ESTA has a developmental vision that instead of just facilitating evictions, the state could be saying, okay, actually, these people could become the owners of the house or the little plot of land on which they already exist. But this has not been used. Why has it not been used? There's some very powerful points made within the high-level panel report about this. Another question is about why this is a law that is so widely flouted. So Section 23 of ESTA actually makes it a criminal offence to illegally evict somebody, outside of a process that involves an order from the magistrates' court confirmed by the land claims court. And yet we've not seen a single prosecution. In fact, SAPS doesn't even have it on their database as a crime for which you can prosecute. So there's widespread flouting of this. The Human Rights Commission is picking up this issue. Another issue that they're picking up and that I think will become the subject of a discussion with the Department of Rural Development and Land Reform soon is the question of farm schools. Because a lot of farm schools have been closed down, and lack of access to scholar transport means that effectively this is denying children of farm dwellers the right to education. So we're going to have to look at that. There's an ESTA amendment bill currently before Parliament. There are two things that it says that are arguably problematic. Firstly, it narrows down the definition of a dependent. So if you have a permission to occupy on a farm, your right to occupy also extends to your immediate family, right? But now they're narrowing down. What they're proposing to do is to narrow down that right to only those dependents who you have a legal obligation to support. So it's narrowing. There's a question about the right to family life. Secondly, there's new imposition of obligations to maintain farms. I think that one of the big things to look at now, and we'll get back to this when we talk about Section 25, the property clause, and what we might see in terms of expropriation without compensation. There's one very important case that came before the Land Claims Court in 2016. It's called the Imposition case. Acting judge in the Land Claims Court, Advocate Tembeka Nrukatobi, actually made the first judgment which said, we are going to compensate you not at market price. And there's an open, and that was a case, it was a labor tenant case from KZN, and it was later struck down by the Supreme Court of Appeal. And there's an open question. Is it going to be appealed up to the Constitutional Court? We'll have to watch this space. But I think more broadly, there's actually big questions to follow. Who are the farm workers? What do they want? Do they want their own land? Some of our research and people who we've worked with suggest that, in fact, a lot of farm workers, they want to, the choice of, like, do you want a job or do you want land is a false choice. That often people, in a context in which farm employment is becoming much more insecure, very seasonal kinds of employment, that people want to have a little hook on the land as well as being able to sell their labor. So I think this is a complex issue. There's an urgent need for training. For instance, the NPA, magistrates don't even know the law clearly, and we see bad judgments coming out of the magistrates' court and the police, who are not addressing this massive process of forced dispossession of people off the land. Can I just start with the last one? So the Afra case that you referred to is called the Mwelase case, Mwelase, and it's the Hilton case, and it was a class action suit, which is basically where a whole lot of labour tenants took the state to court to argue that the state has failed to implement this legislation, and they've put in their claims. All the claims were, the claims process was up to 2003, 21,000 claims, many of them large communities, some of them extended families, and the state has simply failed to implement it. In fact, twice they lost all of the database and had to revive the process of people actually putting in their claims. And now what the situation is that there's been a constitutional court judgment that appointed a special master of the court to oversee this process. In other words, where the state has failed so severely, the court has said, we're going to appoint a special master to oversee this process, and you will be accountable as the department to the special master. So I think that's what can be done to protect the people in Hilton. Well, I think that it's a political process right now. Maybe, Ben, you want to add on this or on the Salms Delta issue?
Just to say, government has appealed the court ruling that there should be a special master of the court. Why? Why is government appealing a decision which is helping government?
Ben, just a correction, it was the Land Claims Court in December in 2016
yes.
that issued the
yes, you're right.
Then the government took it to the Supreme Court of Appeal.
Yeah.
So it is pending there, and
Yeah.
if the government loses, it intends on taking it to the Constitutional Court.
Yeah, exactly.
It's nice to find someone who's more well-informed than you are.
Nice.
It's great. But just to clarify, it's not the Esther Amendment Act applies to the Extension of Security of Tenure Act. Labour Tenants Act is a separate piece of legislation.
I'd like to talk about the Salms Delta story. For several years, government saw Salms Delta as a bit of a sort of poster child for equity schemes. And in the context in which the state has not been able to find very durable forms of land redistribution, the idea that instead of redistributing land, you actually buy equity within existing commercial farming enterprises has become quite fashionable. Salms Delta was set up without state funding. It involved a farm being mortgaged in order to buy a neighbouring farm, which is registered as in full private title as the property of the farm workers. The entire project, in many ways, then, is not replicable. It's only replicable to the extent that private owners want to mortgage their own property to buy additional property for others. But I think that it raises big questions about equity schemes. And, of course, our former minister, Gugilen Quinty, was quite a fan of equity schemes, and he proposed this 50-50 model, where the state would buy out a proportion of properties, but the owners would retain control of them. So I think that it's not a clear example. Of course, the debate about equity schemes centres on two very, very distinct views. And the one is, particularly, say, within the Western Cape, in high-value sectors within agriculture, what are the feasible options for poor people to become co-owners of property and get income streams and capital from that? Is an equity scheme, in fact, a very pragmatic solution to providing people with a stake in the economy? Or, in fact, has it been a mechanism of state funding being used to bail out failing farmers while still allowing them to retain ownership of the land. So this is the spectrum of opinion on this issue of equity schemes.
Just to add on
Yep.
that, Soames Delta has run into problems of profitability, and it applied to become a beneficiary of the 50/50 scheme. And they got 65 million rand from the National Empowerment Fund in order to add to the percentage of ownership of the enterprise by the farm workers, from I think it was 32% up to 45%. But subsequently they have run into continuing problems, and they went into business rescue. So this illustrates that at the poster child of equity share schemes, Soames Delta, particularly when seen through the lens of the so-called radical 50/50 scheme, is actually a scheme whereby government bails out failing enterprises under the guise of, real change. And farm workers, by the way, very rarely ask for shares in farms. They want improved wages and better conditions. And at the National Land Tenure Summit in 2014, I think it was,
Yes.
a commission investigated, spent 3 hours talking about farm workers. Ruth was there. They said nothing about this 50/50 scheme. They wanted improvements in conditions and wages. They reported back, and the minister, Mr. Nkwinti, stood up angrily and told them to go back to their commission to discuss his proposal. This is the way policy's been made recently.
So I think, it is an important issue to look at why it is that there are these flagship projects that are getting large amounts of public money, and why more modest needs for land, for instance, people wanting small holdings around rural towns, these other kinds of land needs are being ignored.
Any other questions?
So, for instance, sorry, that responded to the question also, sorry, you asked, I think, Michael, about why no housing, why no program? Well, there's never been an earmarked budget for farm tenure. So within the budget, we have one for restitution, we have one for land reform, which incorporates redistribution, plus Ingonyama Trust, plus farm, but there's never been an allocated budget. There's no program for farm tenure. And so the whole of government's program around farm tenure seems to be allocating money to provide funds to the Land Rights Management Facility to employ private attorneys to defend eviction cases. There is no proactive plan for farm dwellers.